case that is set to be heard is case number 28674, City of Twinsburg versus Jennifer Milano. Now, the City of Twinsburg has waived their argument. Ms. Milano's counsel is present.
Good morning, Your Honor.
So we'll be hearing just from you. And we'll give you 15 minutes for your argument. We've read the briefs in this matter and are ready to proceed whenever you are.
Good morning, Your Honor. William Norman for Appellant Jennifer Milano. May it please the Court. Your Honor, this case is on appeal from Stone Municipal Court on the Court's decision to deny Jennifer Milano's motion to withdraw her guilty plea under Rule 32.1. Your Honor, today I want to first go through the standard of review, address the case law cited in the appellant's brief, distinguish the case cited in the State of Ohio's brief. But a brief background. On or about November 10th, 2015, Jennifer Milano, a nursing student who was several months pregnant, got into an argument with her boyfriend. During that argument, the police were called. And for reasons unstated in the record, Ms. Milano was determined to have been an aggressor in a domestic violence arrest, or in a domestic violence incident leading to her arrest. There are no injuries noted in the report or anywhere in the record. Your Honor, after sitting all night in a jail cell, Ms. Milano was arraigned by video in the Stowe Municipal Court by the Honorable Judge Kim Hoover. And this is where the appeal starts. So we requested the transcript of the proceedings for that plea, for the arraignment, where a guilty plea was entered on Ms. Milano's behalf in the judgment entry. And upon reviewing the record of those proceedings, we find that there is no evidence of certain advisements. So that is the subject of the appeal. The standard of review in this case, Your Honor, is for a post-sentence motion to withdraw a guilty plea, the movement must show a manifest injustice. Now, while that seems like one of those very high standards that is almost impossible to get, we do have a very concrete example of when a manifest injustice is reached, and that is where a movement can show that their guilty plea was not made knowingly, voluntarily, and intelligently. So as soon as the appellant can, or the movement can show that her plea was not entered knowingly, voluntarily, and intelligently, you reach manifest injustice. So we don't need to kind of imagine what that might be. That's a very concrete set of standards. A plea is not made knowingly, voluntarily, and intelligently where a defendant is not advised of her constitutional rights, including the right to subpoena, the right to a jury trial, and other advisements such as...
Let me stop you right
Please.
there. Your client, you can agree pled guilty, correct?
Yes, Your Honor.
And would you agree with me that domestic violence, first-degree misdemeanor, is considered a petty offense?
Yes, Your Honor.
Are you familiar with the case law that says in such circumstances, and it's actually case law from this district following the Supreme Court, that a guilty plea is a complete admission of guilt, and so the only thing we would look to in terms of advisement is whether or not your client was advised of the effect of her guilty plea.
Your Honor, respectfully, I believe that she does have certain constitutional rights, the right to subpoena, the right to jury trial.
She does. Do you concede that the case law is that the only thing we would look to in review is whether or not she was advised of whether she was told the effect of her guilty plea?
No, Your Honor, respectfully, I would disagree. Your Honor, I believe that it is the case that if a defendant is not aware of her constitutional rights, her constitutional trial rights, that she cannot knowingly waive them, cannot intelligently waive them. And so this is a case where Ms. Milano was without counsel, has no familiarity with the criminal justice system, and was not advised by the court as to several of her critical constitutional rights. And therefore, she could not knowingly, voluntarily, and intelligently waive them, Your Honor. So the appellant cites two 8th District cases, which we believe are on all fours. We did not see a 9th District case on all fours. We didn't see that in the appellee's brief. We looked at State v. Brown and East Cleveland v. Zappo. And these cases are starkly similar to the case at bar. That is to say, in Brown, the defendant moved to withdraw his guilty plea, and the state argued that because only a partial transcript was provided, that regularity must be presumed, and therefore the motion to withdraw guilty plea should be denied.
What was the offense in that case?
The offense in that case was also a petty offense, Your Honor. Specifically,
Well, you don't need to be specific. I was curious if it was a petty offense or not.
yes, it was a petty offense, Your Honor. And in that case, actually, the only thing that the defendant was complaining about was not being told to the effect of the plea. Whereas in this case, not only are we similar in that there is no complete transcript of the case, but there is no evidence that she was advised of her constitutional rights to trial. How could she waive these rights without being advised of them?
Why is there only a partial transcript here? Where did it stop?
Your Honor,
Maybe the better question is, where did it start?
Sure.
Either one.
So, just as in Brown, the plea colloquy, the recording of the plea colloquy starts in the middle, admittedly. And that is due, we understand, to the trial court in some sort of technical error, not pressing the button, or pressing the button and not having the recording go for whatever reason. But it is clear, and it's undisputed, that there is no complete transcript, not due to any fault of the appellant, but rather the court itself, through what perhaps is an understandable technical error. It happens, so many arraignments and so many hearings. But it is certainly the trial court's failure to preserve that record that leaves us with only a partial transcript. And so, again, we believe that the overarching question in this case is whether a trial court can insulate itself from review by first making a mistake in failing to preserve the record, and then secondly, simply averring, no, I gave all the rights, and that's it. So in those cases, then, there's no meaningful review possible. The trial judge is the judge of his own credibility in stating that, no, I gave her all the constitutional rights. The only record that we have to say otherwise is incomplete, not due to our mistake, but...
But wouldn't the judgment entry be a record?
Well, the judgment entry is again, the judge stating that a guilty plea was entered. But there's no... Now, normally you would have an acknowledgement of rights form. That's typically what happens. It's kind of like a secondary, a fallback position, if you will. Here, there is no acknowledgement of rights form. It's not signed.
Well, what about the part of the entry that says the V indicates that these things were done by video because the defendant wasn't present in court at the time? Is that of no consequence?
It's not of no consequence, Your Honor. It's simply the fact that there's no evidence that Ms. Milano even saw this acknowledgement of rights form. So whereas in Brown and in Zappo, they actually have an acknowledgement of rights form, and still, and it even states the effect of the plea, and still, because the court didn't address it, the Court of Appeals said that that's not a knowing, voluntary, and intelligent plea, and they reversed the trial court's decision. Here, we don't even have the acknowledgments of right form that actually was signed by the defendant. And so there is simply no evidence in the record that she was ever advised of several of her critical constitutional rights. In addition, the statutory penalties associated with domestic violence,
You talking about the enhancement?
I'm sorry, Your Honor.
The enhancement aspect of
It does state in the And the transcript we do have, that it's an enhanceable offense, although the specifics of that are not, you know, fully vetted out. That said, I don't believe that's necessary. I think that for advising of the enhancement, simply saying it's an enhanceable offense.
Isn't there a problem with the number of courts that use audio recordings instead of transcribing these hearings? I mean, how long should they hold on to those recordings before they tape over them? In this case, it was, I think, a year, wasn't it?
No, Your Honor. We asked for the transcripts in February of 2016 after a November plea. So this is, I mean, we're talking 3 months. So I could completely understand your objection, Your Honor, if this was a year down the line. And we could say, look, even if it was the court's mistake in the first instance, this, it's been a year, you should have done this sooner. How long are they supposed to hang on to this? But certainly 3 months is not an obscene amount of time to come back and ask for the transcript. And in fact, there's no contention here that the court simply taped over it, or that because it was holding on to it for some time, now it becomes something that they're not going to hang on to.
But in your case, the court would not have been aware of it, would they have, until you filed your motion?
Oh, no, in February, I believe it's March. In February, I'm calling about it and saying, how can I get this transcript? Because that's when she comes to see me. I believe it's on March 1st that there's actually a record entry that states, you know, a request for the transcript was put in. So again, this is not an obscene amount of time, particularly for, you know, a motion to withdraw a guilty plea. If it's going to happen post-sentence, this is actually one of the, you know, more expedient, you know, cases where it's just a couple of months down the road. Your Honor, additionally, I would like to discuss the state of Ohio's brief. In the state of Ohio's brief, they offer State v. Williams as kind of their lone case for analysis. And State v. Williams is easily distinguishable from the present case. In State v. Williams, there's a video transcript of the entire hearing. And under the rules, the attorney is responsible for getting a typed transcript for the portion relevant for the appeal. Because the attorney did not get a typed portion, the Court of Appeals stated, well, we're going to presume regularity because you haven't given us a transcript, though it was in your power to give. And that is obviously clearly distinguishable from here, where Ms. Milano did everything that she could to try to get this complete transcript. And it was, unfortunately, and certainly I don't think maliciously, the trial court's failure that kept her from being able to have a record and to pursue a meaningful appeal.
Should we not presume regularity in the first portion of the proceedings?
No, Your Honor. In fact, in State v. Brown, which is cited in our brief, it states that I thought I had it here, but 16. No, it's 20. A reviewing court cannot presume from a silent record that a defendant enters a guilty plea knowingly, intelligently, and voluntarily. And they actually address this in Brown, where it's a partial transcript due to the recording picking up in the middle of the colloquy, and it states, moreover, Brown's failure to provide a complete transcript was not due to her or her counsel's failure to provide the transcript, because a complete transcript does not exist. Furthermore, an Appellate Rule 9c statement would not add any additional information for this court to consider. In our affidavit in the trial court, we stated we were not advised of these key constitutional rights, and so a 9c statement would essentially say the same thing. There would be no additional benefit for the court in putting forth a 9c statement, because it would be us saying that we did not get the advisement, and the trial court saying, well, we believe you did. So here, as in Brown, the partial transcript is not the fault of the defendant. Here, as in Brown, there were critical advisements that were not recorded in the partial transcript, and we believe here, as in Brown, and we actually believe it's a little bit more egregious than Brown, because again, no acknowledgments of right form here with Ms. Milano, and here, not only the effect of the plea, but constitutional rights were not advised. So again, it's not disputed, at least by the appellee, that if the trial court did not advise of these constitutional rights, that's that it's impossible that Ms. Milano would have entered a knowing, voluntary, and intelligent plea. That's not disputed by the appellee. They're saying that she was, and the reason they state that she was is because they want to presume regularity. And if that is the case, if it is the case that we will presume regularity where the trial court fails to record and to maintain as appropriate the transcript of the proceeding, then we have essentially insulated the court from any meaningful review. They say, yes, we gave it. And that, by the way, that decision, the motion stayed for some time before the court said in February of 2017, so this is 15 months later, said, no, I remember. I gave her all the rights. So of all of the cases that came through in the interim between Jennifer Milano and February of 2017, he remembers this specific one. And I am not here to impeach the good name of the Honorable Judge Hoover. I am simply saying that if we allow the court to simply aver, I did everything right, after making a mistake and not keeping the transcript, then we have insulated them from review. At the very least, if that were the case, then it should also be the case that during a motion to withdraw, that judge should recuse themselves, because they are now a witness in the case. They are now a witness to what was said. And so they are judging their own credibility versus the credibility of my client. And so if it were the case that a trial court could simply aver, then at the very least, we would ask that the case be remanded for a hearing to determine whether the trial court's averment is superior to the, Ms. Milano's affidavit that she did not receive the advisements. But I do...
Your time is up, Mr. Gold.
Okay.
So thank you for your argument and your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk, of course, will mail the decision to you on the day it's released, and of course, the opinions are also posted on the Supreme Court of Ohio's website. So thank you again. The court's adjourned until April 3rd, where the court will be sitting in Summit County.
Thank you.